The employment relationship is the legal link between employers and employees. It is when a person performs work or services under certain conditions in return for remuneration. It is through the employment relationship, however defined, that reciprocal rights and obligations are created between the employee and the employer. It has been and continues to be the main vehicle through which workers gain access to the rights and benefits associated with employment in the areas of labor, law, and social security. The right to strike, the right to work, and the right to collective bargaining. Industrial disputes between the employee and the employer can also be settled by discussion and negotiation between these two parties in order to arrive at a decision, commonly known as collective bargaining, as both the parties eventually agree to follow a decision that they arrive at after a lot of negotiation and discussion. Collective bargaining involves negotiations, drafting, administration, interpretation of documents written by employers, employees, and the union representatives, and organizational trade unions with open mind. Collective bargaining has the following characteristics. It is a group of action. It is a continuous process and a bipartite process. It is also flexible and mobile. There are four important methods of collective bargaining, namely negotiation, mediation, conciliation, and arbitration. Arbitration is often provided for in collective bargaining under certain contingencies and for certain purposes, especially when the parties cannot reach agreement, and in the interpretation of an agreement through negotiation. Conciliation is a term often applied to the art of collective bargaining, a term often applied to the action of the public board which attempts to induce collective bargaining. Mediation is the intervention, usually uninvited, of some outside person or body with a view of getting conciliation or to force a settlement. Compulsory arbitration is extreme mediation. Your drawback to using this type of negotiation system is that, even though everyone gets a say in what happens, ultimately the majority rules, with only a few people determining what happens to many.
A strike can be understood as a curtailment of work due to the collective refusal of workers to work, which occurs as a response to employee grievances. A strike is a situation in which the workers act in concert for stopping or denying to resume work. The relationship between the employer and employee continues to exist, though in a state of hostile suspension. There are many causes for a strike: a dispute relating to minimum wages, salary and incentive issues. The increment is not up to the performance, hours of work and interval timings, holidays and leaves with pay, and finally, wrongful dismissal of workmen. There are different types of strike. First of all, there's a hunger strike, which is a strike in which the employees go on fasting near the workplace or at the residence of the employer to force them to redress their grievances. The second type of strike is called stay-in strike. Is where the employees come to the office as usual, they take their seats, but they do not work and also deny to leave the office premises when asked to do so. There is also the go slow strike. It is also called slow down strike. It is one in which the workers do not stop working but slow down the entire process by deliberately delaying the production, which results in the reduction of output. This amounts to a serious case of misconduct. It is more harmful than the complete cessation of work by employees, as the resources get wasted due to delayed working of employees. There is also an economic strike, which is the cessation of work by the laborers with the aim of imposing their economic demands like wages and bonus. And then finally, there's a sympathetic strike, which is a type of strike in which the workers of one department, unit, division or industry go on strike in support of the workers of another department, unit, division or industry who are already on strike. Both the right to strike and the right to collective bargaining are contemplated in Article 151 of the Treaty of the Functioning of the European Union.